May it please the court, Daryl Meggs on behalf of Appellant Elise Brown. As the court is aware, we have appealed the district court's grant of a summary judgment as to my client's claims that she was subjected to excessive force, as well as subjected to an unlawful arrest lacking probable cause. Our appeal is largely based on the grounds that the district court erred by granting the motion as to each of the plaintiff's claims on qualified immunity grounds. It's our position that existing precedent establishes that the defendant's alleged conduct violated the plaintiff's or our client's clearly established rights. In our opposition to the motion for summary judgment, we relied heavily on this court's 2014 decision in the case Green versus City and County of San Francisco.
So can I ask you about the case? It seems like one of the fundamental differences there is that's different from here is, and maybe you can clarify this for me. I don't think there was video footage, or it's unclear to me in Green how much video footage there was. But what the district court, or excuse me, what we decided in Green was that there were a bunch of factual disputes, and those factual disputes, people were testifying about what happened. And that was largely the basis. We can parse it out because I know there's two different issues there, but that was largely the basis for why we denied qualified immunity and found at least a constitutional violation based on the factual disputes, or a potential constitutional violation. Here we have pretty substantial video evidence. Which way does that cut? I mean, there doesn't seem to be a lot of factual dispute about what happened here. We're kind of in the inference era.
Absolutely, Your Honor. And one of the main reasons for our appeal was that the court was required to apply all inferences in the favor of the non-moving party, which was ourselves, and they did not. The inferences they applied in the favor of the defendant officers. The fact that there is video footage does assist us. I think it leans in favor of our case because it clearly shows that the circumstances of this particular case are very strikingly similar to the circumstances of the Green versus County of San Francisco case.
I'm not sure about that because Green, one of the factual disputes was whether the gun was trained on the plaintiff. And the district court held here, and I couldn't come up, I mean, I don't know what else the district court was looking at, but from the video evidence, said that at least after she knelt down and was handcuffed, that the guns weren't trained on her anymore. And that, I mean, do you dispute that? Do you think the guns were trained on her? They were pointed at her?
Yes, there is a dispute as to Officer Scott, who was aiming a 40 millimeter launcher shotgun at her at the time she was handcuffed. She testified in her deposition that when she was being led back to the car in handcuffs, his shotgun was still trained on her. Unfortunately, there's no video evidence one way or the other, but we do have the evidence.
There is video evidence that he had a shotgun out and pointing originally.
Yes, Your Honor, there is.
Look at him. You have to look hard, but you can see him there.
Correct,
but
Your Honor.
What he was doing when she was actually being handcuffed, you can't see.
Correct, yes. As to the time in which she was handcuffed, there's no video evidence.
But does it matter? One of the things that's bothering me as to is that the Green case relies heavily on Robinson. Robinson, and some of the other cases in this court seem very clear that what they're regarding as excessive force, which I almost think is an unfortunate term in this instance because it's ultimately is it an unreasonable arrest. But in any event, is that the gun was pointed at their head in very short distance. And Robinson is very clear about that. There was a more recent opinion in, let's see if I can find it, in Thompson versus Rare, which seems even to cut back some on Robinson in that regard. And then Green did seem very focused on the question of whether the gun was directed at her or directed down. Why that matters so much, I don't know, but our case law seems to think it matters a great deal. So what do we do with that in this case?
Well, we do have evidence.
But in other words, even Scott, he was not near her, right? He was on the other side of the car.
Correct.
Right.
He was on the other side of the car, but we do have evidence that there was a gun aimed from Mr. Scott at plaintiff while she was being led away in handcuffs. But there is also Ninth Circuit precedent showing that the act of brandishing a firearm at a plaintiff is a level of force that can rise to the level of excessive force. At the time at the time our client was forced to the ground.
What case is that? Brandishing meaning having it out but not
Correct.
pointing
Just
it?
having it visible, basically. So you're saying even if they were pointing it at even if we'd agreed with the district court that there wasn't evidence that it was pointed directly at her, you're saying that's still a constitutional violation and clearly established that you can't do that in these circumstances.
Correct, Your Honor. Looking at the video evidence, Officer Gregory.
Oh, wait a minute. What about the case? What case supports that proposition?
Apologies, Your Honor, with the court's indulgence, I was cited in our brief. I can't find it at instant moment, but I can certainly locate that and allow you and allow it and present it to you for your consideration. Here, actually, I apologize. I do have it here. It was in the Robinson case. It states that when the police only have reasonable suspicion to make an investigatory stop, drawing weapons and using handcuffs and other restraints will violate the Fourth Amendment. That's Robinson versus County of Solano.
That's because it's an arrest and they don't have probable cause for the arrest. And one of the problems in this case and in these various cases is that it's easy to mix up the two questions. That is, when does it turn into an arrest such that you need to have probable cause?
Correct.
And when is there excessive force? That part of Robinson, as I understand it, was discussing the question of when does it turn into an arrest, and not the question of whether it's excessive force.
Yes, Your Honor. And if I could continue, there was a further portion of that quote that says a police officer who terrorizes a civilian by brandishing a weapon in that civilian's face may not cause physical injury, but he has certainly laid the building blocks for a civil rights claim.
But the rest of the, what they mean by brandishing there, it seemed pretty clear that they were talking, they said several times, pointing a gun to the head. And they kept repeating that phrase, you had to be pointing the gun to the head.
Certainly, Your Honor. And if you view the video portion where...
General principle that pointing a gun to the head of an apparently unarmed subject, just coming back and back and back to that.
Correct, Your Honor. But the statement with regard to brandishing a weapon in a civilian's face, they're citing another case, Petta versus Rivera, which is a Fifth Circuit case. But brandishing refers to displaying a firearm as opposed to aiming it or training it. I understand that case also involved facts of it being aimed, but the act of brandishing a firearm in a civilian's face is an intrusive use of force.
Counsel, part of the problem, and I don't know what to do with this, because we watch these videos and you kind of look at a gut reaction and then you go back and read all the cases and then you go back and watch the video. But I watch this and I'm like, this is a very unfortunate incident. No question about it. It would be scary. But the officers didn't seem out of control here. They didn't seem to be brandishing. I wouldn't use that term. I wouldn't use threatening. I wouldn't. They were trying to keep a controlled situation. Maybe they should have handcuffed her. But is that really how we're unhandcuffed her sooner? But is that really how we're going to decide these cases on a constitutional violation? Is just get in and second guess every decision. They seem to say, we got a problem here. We've got a stolen car. Once they figured it out, they seem to have resolved it.
Understood, Your Honor.
And maybe they could have unhandcuffed her a minute ahead of time. But is that really where we're going to find the constitutional violation in these circumstances?
Well, if we're to follow the text of the Green decision,
okay, so let's go back to Green. Because one of the other differences is, in Green, they didn't do a visual inspection of the license plate. And so, it was unverified. Here they verified it. I'll be honest. The only way that this seems to have happened is if she misreported which of her cars was stolen.
I don't think anybody suggested that.
Well, yeah, there's
how else would this have happened? They got. You think that that they wrote down the wrong license plate for a car that she happened to own? The chances of that are so infinitesimally small.
Well, Your Honor, she owns 2 Oldsmobile sedans.
Apparently owns a third, she said. She's an Oldsmobile fan.
She's an Oldsmobile fan, you're correct, Your Honor, and she owns 2 Oldsmobiles. There's no indication as to where the error came in, whether she made the error or...
Let's be realistic about this. You think that the sheriff would have written down the wrong number and it happened to be the second Oldsmobile that she owned. I mean, anyway, to a certain degree, it doesn't matter. The fact
Correct.
of the matter is, this was an unusual error, and it happens. They figure it out, and they resolve it after that.
Correct, Your
But
Honor.
that's a difference in Green. Green wasn't that. They didn't follow protocol. The district court below said they followed protocol here.
That is a difference, Your Honor. However, one of the key holdings of Green is that the suspicion of a stolen vehicle does not justify the use of intrusive measures in and of itself. And I think that's the point that is crucial here.
Counsel, here's my problem. If they were acting reasonably by pulling her over because they verified that the plate was reported stolen, and if it was reasonable to have her exit the vehicle in the way in which they did and show her waistband and back up to them, is there a point at which the measures they are using become unreasonable? So when this small woman, elderly woman, is right next to them and they know she has no weapon and she's not resisting in any fashion, at that point, is there an excessive force claim because they made her kneel down and they handcuffed her and there were reasonable, less intrusive alternatives? And is your basis for saying that Green or another case?
Yes, Your Honor. Ninth Circuit precedent also holds that if there are available less intrusive measures that can be utilized, that officers are to use those measures, as well as the Chino Police Department's own training advises them to de-escalate, even in situations of high-risk traffic stops. As soon as they determine that no threat exists, they are to holster their weapons, they are to de-escalate. And I submit to you that they should have realized that no threat existed upon the appearance of Miss Brown stepping out of the vehicle. She's an 83.
How does it factor in that the color and model of the car didn't match?
It factors into the reasonable suspicion analysis. The fact that she was driving a blue 1991 Oldsmobile Aurora and the suspected stolen vehicle was a cream-colored 2001 Oldsmobile touring sedan. So the make matches, the models don't match, the years don't match, the colors don't match. So that is that should be something that should have alerted the officers to do more investigation prior to using these highly intrusive tactics.
You think that's only relevant to the false arrest issue and not to the excessive force issue?
I think it goes to the reasonable suspicion justifying the Terry stop. I think it does not go to the excessive force
in
analysis.
the sense that one of the Graham factors is the seriousness of the crime and whether the crime actually happened or not. I mean, how much belief there is that this crime actually happened, and there is some case law that supports that. It does feed in the sense that once the suspicion is weakened, it ought to affect the excessive force question.
Correct, as well as the.
And as I recall, both the defendant officers testified or put in their declaration that according to their training, and I have a question about that in a moment, if there is not a match on the color of the car, they don't have to do a high risk stop. They can, but they don't have to. Is that right?
I believe that is correct, Your Honor.
So more generally, how does do we have case law that says that if their training says they should do something, then that's it? They have qualified immunity for it?
No, Your Honor, and that was one of the grounds relied upon by the district court was that they followed their training. But, Your Honor, that's clearly an inference in their favor.
Well, but suppose they did follow their training. Is that the end of the qualified immunity question?
Your Honor, that question I don't believe has been clearly addressed, whether following their training insulates them.
Well, it hasn't been, and I'm just wondering whether, offhand, I didn't see any Ninth Circuit law that said, there's Ninth Circuit law that says if you don't follow your training, then you're in a weaker position on qualified immunity, but is following your training a get out of jail free card for qualified immunity?
That hasn't been clearly established. What I would say is that there are aspects of their training that they acted in contravention of, and I cited to 3 separate policies that allowed for them to use de-escalation tactics.
And they testified as well, as I just pointed out, specifically. So that does feed the circumstance of the color of the car into the excessive force question.
Certainly, and they
What about the fact that McCardle ordered this high-risk stop? The officers that are sued, McCardle is not a defendant here, right?
that's correct.
Okay, so you only got the two officers. So this was an issue for the district court, but it didn't seem to get a lot of traction up here about the fact that McCardle was on who ordered it. They were just following. I mean, McCardle said, do a high-risk stop.
Did he say that, by the way?
I don't believe there was ever a statement of do a high-risk stop. He did order the stop, but
And he said it was for a
suspected.
a suspected stolen vehicle, which then might translate, but may not, because they said so, into a high-risk stop. But I didn't hear him say, at least.
No, there was no statement that.
Maybe it was somewhere, is there evidence? It could have been in some part of the tape that didn't have sound, but I didn't remember hearing it.
No, there's no evidence that he ordered a high-risk stop. But one point that I'd like to make, I believe I'm over time, but I'd like to make the point that a high-risk stop is not a self-contained proposition. It's not that the officers have to follow certain tactics. They do have discretion, and the officers testified in their depositions that they do have discretion as to the tactics used. So the fact that...
Particularly on this color issue.
Correct, absolutely. And with regard to the intrusive measures used to extract her from the car, there was no direction from McCardle directing them to do any of those tactics. He sat there silently as they, put the client through all of the paces. And a high-risk stop does not justify the intrusiveness, and that was one of the main points of the Green finding, was that this suspicion of a stolen vehicle in and of itself does not justify the intrusive measures used. That has to come from an analysis of the totality of the circumstances here. An 83-year-old woman of slight build who's completely compliant. There's no evidence of her being armed. Matter of fact, they confirmed she wasn't armed. All of these factors militate in favor of them de-escalating. I apologize.
It's difficult with regard to the way our case law bears out. It would certainly have made a lot more sense for them, while they're talking to her through the microphone, to ask her if it was her car. But
correct.
They never did that.
Absolutely.
On the other hand, I don't know whether that's relevant to excessive force the way our cases run out.
Yes. Well, with regard to excessive force, I don't believe that their subjective belief as to whether or not it was her car was the main factor. The main factor is the immediacy that she posed any threat to officers. And it was pretty clear that she didn't pose a threat. In fact, Sergeant McCardle himself told her, it's clear that you're not a threat. And he had the same vantage point as the defendant officers. And as soon as she steps out of the vehicle, he says, old female. He can tell from looking at her that she's an elderly female. She does not pose a physical threat to the 7 or 8 officers on the
When
scene.
he testified, he said he thought that meant she was around 60, so.
I believe those were the defendant the defendant officers put her in her 50s or 60s.
McCardle said that too.
McCardle did as well, but he...
Of course, what do you mean by old? I don't think.
I think we're trying to set the bar a little higher.
No, I understand. I completely understand. But the best evidence for us was his statement that it's clear you're not a threat to us. And if it's clear that she's not a threat, the gun should have been holstered. She should not have been forced to her knees or
I think
handcuffed.
that hits on the rub. Well, and Judge Beatty had a question.
I did have a question. So it seems to me that we're perhaps conflating the reasonableness of the arrest and the amount of force or the intrusion used in the incident. So if we were to conclude that they had reasonable suspicion for the stop and that they even had probable cause to, if not overtly arrest her, take conduct that is in fact an arrest because she wasn't free to leave, could there still be excessive force? Could there still be excessive force in the way they confronted her and put her on her knees and put her in handcuffs when they were very close to her and could see that she did not appear to pose any threat? I mean, I guess what I'm getting at is, even if the wrongful arrest or unreasonable arrest claim were to fail, do you still think you have an excessive force claim? Absolutely,
because she posed no threat to the officers. They were similar to Green. She was severely outnumbered. She was perfectly compliant at all times, never attempted to evade. She posed no threat. And as I mentioned, Sergeant McCardle himself said, it's clear you're not a threat. Well, in that case, you don't have to force her to her knees. You don't have to handcuff her, and you don't have to continue to hold her at gunpoint or brandish your weapon next to her head as she's on the ground in handcuffs. So certainly,
By the way, the Fifth Circuit opinion, as far as I can tell, says by brandishing a cocked gun in front of the civilian's face. That's what it meant by brandishing. So it's not very helpful to you. But I have another question, which is sort of the obverse, I guess, of Judge Beatty's. If we thought that there wasn't probable cause, is there a clearly established law that it wasn't probable cause?
there is. I cited to the decision in Rhodey, which basically stated that Rhodey versus City of Roseburg, probable cause was found to exist where the officer had reliable information indicating the vehicle was stolen, and the plaintiff presented no evidence to rebut evidence that the vehicle had been stolen. That's not the case here.
Well, I know that's when there is probable cause, but what about when there isn't probable cause?
I apologize, I must have
In other words,
misunderstood the question.
it didn't say, and there wouldn't have been probable cause if both of these things hadn't happened. It just said there was probable cause because these things happened.
Because they did not rebut the presumption, and she immediately rebutted the presumption. Also, there was not.
Oh, I'm sorry, how did she immediately rebut the presumption? That's the problem, they didn't ask her. I mean, it would have made, if she were in the position of Rhodey, it all wouldn't have happened because they would have asked her and she would have explained the whole thing and presumably showed them a registration, and that would have been the end of it. But
Correct.
They didn't ask her. So the question is, do they have probable cause? Is there clearly established law that they couldn't have probable cause without something more than what they had, i.e. without knowing, as they did in Rhodey, that he couldn't account for the registration or ownership of the car?
The defendant, the appellee cited to Tatum versus City and County of San Francisco, a Ninth Circuit decision from 2006 that said probable cause exists if at the moment the arrest was made, there was a fair probability that the suspect has committed a crime.
That's true, and the question is whether, in this set of circumstances where the color doesn't match, the model doesn't match, the number does match, and nobody asks her, so they don't have anything additional. Is there a clearly established law that isn't probable cause?
Well, Your Honor, they do ask after they've employed the intrusive tactics.
Before.
I would argue that
When they
Sergeant
arrest her.
McCardle.
When they arrest her, if one takes it to be an arrest because of the intrusiveness and so on.
Well, there would be probable cause if there was a fair probability at that moment when she was placed under arrest.
Okay.
That she had committed the crime.
Clearly established law that there isn't. That's what I'm asking you.
Is there a clearly established law that there's not a fair probability?
Yes.
I don't have a case on point that would say that there's not a fair probability, but under the facts of this case, I would argue that the discrepancy in the models, as well as Sergeant McCardle, immediately as Ms. Brown is led to the police cruiser, McCardle can be heard telling officers, check and see if she's the registered owner of this vehicle. And that suggests that he has not formed the opinion that there's a fair probability that this 83-year-old woman actually stole this car.
Conversely, doesn't it suggest that this stop was inherently different from what happened in Rhodey, where the plaintiff was pulled over for speeding? So it wasn't a felony high-risk stop. He was pulled over for speeding. They approach him, they ask for license and registration, which is pretty standard. But because this vehicle was pulled over because they had a plate that indicated it was stolen, and that was confirmed, they didn't approach her window like that. They didn't ask her for registration or proof of ownership until minutes later, because I don't think they had an opportunity to do that any earlier. So, how does when they ask her for proof of registration change whether this was an unlawful arrest or excessive force?
Well, because the totality of the intrusive methods used is what arguably causes this to rise to the level of arrest. So I believe Your Honor's question was whether at the moment of arrest, which would be when these tactics are employed, was there a fair probability that she had committed a crime? With regard to the high-risk stop, I believe that bears more on the tactics used to pull her from the vehicle. And we're not arguing that they should not have used a high-risk stop to get her out of the vehicle. We're arguing that at the moment you see this is an 83-year-old woman that does not pose any threat.
Let's say they didn't have their weapons out and they'd made her kneel and handcuffed her. Would you say that was unreasonable use of force?
If it's unnecessary, absolutely. Officer Gregory himself said he considered.
But there you have a qualified immunity problem because there is no case law, right?
With regard to, I'm sorry.
They didn't have the guns out.
There's no case law where there's a similar situation with no guns, but the kneeling and handcuffing. You're correct. But the officer's own training as well as, countless Ninth Circuit decisions say that where there's no need for force, any force used is inherently unreasonable.
It gets back to where this really case comes down to at the heart of it with Green is how important is it? Because, I mean, if we're going to assume that it's clearly established, which is all the district court found, it's not clearly established that this was an excessive use of force. The difference here between the fact scenario I just gave is whether you're saying they should have reholstered their weapons. And if they didn't reholster them and just didn't point them at her, I think that's what we're left with is that excessive force, or did they have to actually reholster their weapons in order to get
their own training,
qualified immunity?
Their own training, as well as Ninth Circuit precedent states that they should have employed less intrusive methods. So as soon as they determine that she's not a threat, she's completely compliant.
Well, that's the question, though. Is less intrusive methods pointing the guns away, or is it holstering?
Holstering the weapons. And Chino police policy specifically says once you...
It does say holster. Absolutely.
I can give you the citation, but it says as soon as you determine that there's no threat, you are to reholster your weapon. It's section 300.4.2 entitled Displaying of Firearms. States that the officer reasonably believes that a threat exists based on the totality of the circumstances presented at the time. In parentheses, it says, example, high risk stop, tactical entry and armed encounter. Firearms may be directed towards such threat until the officer no longer perceives such threat.
Where does it say reholstered?
Firearms may be directed towards such threat. Apologies.
Where does it say reholstered?
The very next sentence, I'm sorry, Your Honor. Once it is reasonably safe to do so, officers should carefully secure all firearms. And I argue that once they realize this is an 83-year-old completely compliant woman, that it was safe and reasonable to reholster their firearms at that point.
What if the weapons were not an issue? I'm more focused on forcing her to kneel and then handcuffing her behind her back at a point when she doesn't seem to pose any threat. So one of the officers, I think it was Gregory, said he considered not having her kneel.
Correct.
So if they had not had her kneel and we're parsing this so finely, but if they just didn't handcuff her or handcuffed her with her hands in front of her, is that excessive force? When do we decide, or do their policies say when they can handcuff somebody and force them to kneel?
Yes, their policy speaks on, there's a policy on handcuffing as well. That one states, section 306.3 entitled Use of Restraints, states that when deciding whether to use any restraint, officers should carefully balance officer safety concerns with factors that include, but are not limited to, circumstances or crime related to leading to the arrest, the demeanor and behavior of the arrested person, the age and health of the person, as well as numerous other factors that aren't particularly applicable here.
So if I understand what you're reading, their policies do not say you're making this high risk stop, go by the book, you should always handcuff and put the person in a position where they're more vulnerable, make them kneel and do these things. Those things were not required of them.
That's correct. That was not required. And the statement that, I believe a couple of courts, one of the courts they cited to, the Feeney versus Los Angeles decision, is conflating high-risk stops with the intrusive measures used in those particular cases. And there's no clear policy saying during a high-risk stop, you must use these tactics. In fact, it's quite the opposite, Your Honor. It says that you are to basically assess the factors and you can de-escalate if necessary, particularly if you have a...
He seemed to acknowledge that when he said, when he said, whichever officer said, I thought about not having her.
He did.
So that seems to suggest...
He said it, the other officer said, oh, but you had to do it, which is, she was the sort of trainee person, and I think maybe she was taking things too literally, but...
He said something, he made a statement which we didn't really cite to, but he did make a statement saying, I feel bad to do it, but we got to do what we got to do. But there's no policy saying they have to use these tactics. In fact, it gives them discretion. Officer Gregory stated in his deposition, I do have discretion as to the methods used. So he did not have to make her kneel, he did not have to handcuff her.
If we were to conclude that that was a constitutional violation, that was excessive force to, given this individual, her size, her threat, risk, all of that sort of thing, to do these things, to make her kneel and handcuff her. Is there case law that would have put officers on notice that this was unconstitutional?
Yes, Your Honor, I would argue Green. Green as well as Washington versus Lambert. In the Green case, which is very strikingly similar to this case.
Just so I'm clear, the question was without the weapons,
You're right,
just the handcuffs.
So case law that would put an officer on notice that handcuffing a person and having them kneel when they don't pose a threat, that it's unconstitutional, and you should have known it was unconstitutional.
Yes, correct. Well, I would argue Robinson versus County Solano, in cases involving investigatory or Terry stops, we have consistently applied the principle that drawing weapons and using handcuffs is unreasonable in many situations. And there also are several Ninth Circuit decisions saying...
Are there any of them that just say handcuffing separate and apart? I'm sorry, it sucks that we're trying to parse this so carefully, but that's what our case law apparently does. And so it makes it really difficult to sit back and ask these very pointed questions. But I think that's what would be helpful.
Where handcuffing separate and apart. There are cases...
But there are cases where there was, I remember one, because I was on it years ago, but the handcuffs were said to be hurting and they wouldn't take them off and so on, right? And
yes.
That doesn't happen here, so. I mean, why exactly we're spending, the case law evolves into this degree of detail is another question, but it does seem to.
Well, I would cite two. There's a couple of Ninth Circuit cases. Well, there's one, Headwaters Forest Defense, where the Ninth Circuit held, and it's held multiple times, that where there's no need for force, any force used is constitutionally unreasonable. Also, the Supreme Court case, the Graham case, has cited the clear principle that force is only justified where there's a need for force. If you have a clearly unthreatening plaintiff who's compliant, and you could take them into custody without forcing them to kneel, without handcuffing them, and you choose to do that anyway, then yes, there was no need for that force, and that force is thus excessive.
Okay. Why don't we give you some time for rebuttal? Thanks for your time.
Thank you.
We'll hear from the Appellee.
Good afternoon, Your Honors. May it please the Court, Ross Trindle on behalf of the defendants and appellees, Officer Madeline Briley and Officer Matthew Gregory, excuse me. We're here on the issue of qualified immunity, and specifically whether the law was clearly established at the time. The law is clear that the contours of the right have to be sufficiently clear that any reasonable official...
So does that mean that you concede that it was unconstitutional?
No, Your Honor. It's simply that was the basis of the district court's opinion. As we submitted in our motion for summary judgment, we believe that the facts and circumstances that were undisputed supported the fact that there was no constitutional violation. However, in applying the discretion that the district court had in the two-pronged analysis, it chose, as many courts do, to look at whether the law was clearly established as opposed to doing the fact-intensive look at whether a constitutional violation had occurred. In fact, we do not believe that a constitutional violation occurred at any point with regard to the stop, with regard to the tactics that were used, or with regard to the level of force.
But you agree that the policy does not require them, once they go into a high-risk stop, it does not require them under all circumstances to go through to handcuffing and kneeling?
That's correct, Your Honor, and no policy will, because no policy can account for every situation that an officer or a group of officers are going to encounter in the field.
Did they have any reason to believe that she was a threat, to them for serious bodily injury or death? When she was standing next to them, they could see her size and that she was compliant and her age. I mean, at that point, before they had her kneel down and they cuffed her, did they reasonably think this lady posed a threat?
The totality of the circumstances go beyond simply Mrs. Brown, and I think it's important for the court to keep that in mind.
So you're saying yes, they could think she was a threat just because of past experience or...
I think you were going to say something else. I think you were going to say maybe someone was in the car.
Yes, and that's the situation that we're dealing with.
Didn't McArdle say that it was reported that there wasn't anybody in the car?
I'm sorry, Your Honor.
I thought McArdle said that at the outset that either he didn't see, either his perception was nobody in the car, or whoever ordered to stop it. There was some understanding at the beginning that McArdle had, I don't know about anybody else, that there wasn't anybody in the car.
There was uncertainty as to the number of people
No, but I'm asking you whether he said that. I thought he said that.
No, Your Honor, he did not. He indicated that he knew that there was a driver. He did not know if there were additional people in the car because the car had tinted
Somebody
windows.
said that
But
there was
how-
only one person in the car.
It did not become clear that there was only one person in the car until the car was swept after Ms. Brown was released from handcuffs.
Okay, so we see on the video, they have her kneel down, they cuff her, then somebody guides her back and another officer takes the cuffs off her. But meanwhile, the others run forward and they sweep the vehicle, guns drawn to make sure nobody's in the car. Okay. But what threat did she pose when she was in their custody? She was standing next to them. What threat from a person being in the car? I mean, how does she become a threat because somebody else may have been in the car? They still have 7 officers there with guns drawn to go approach the car. What is she going to do to them that they have to handcuff her?
It's an opportunity for the officers to maintain a position of advantage in the event that something occurs. It is an opportunity for them to control the situation, to keep themselves safe, to keep their detainees safe, and to keep the public safe.
But that,
They are-
I mean, on that theory, then every time they stop a car for a traffic violation, they should be able to pull their guns and get people out of the car and have them handcuffed. Because they don't know, I mean, they may not know whether there's somebody else in the car and that somebody might have a gun. I mean, it's really a question of how perfect their risk control has to be or can be.
In these particular...
Why is it different than if you were just stopping somebody for a speeding ticket and you didn't know if there was somebody else in the car who might have a gun?
Because with a traffic violation, the suspected crime is very low. The gravity of the crime is low. With a stolen vehicle, you're looking at a felony. That increased level justifies more concern and a
Why?
higher level of caution.
Why, once you know, look at the person and you see she's not in any danger, why?
Well, because when the initial stop occurs, officers are trained at the city of Chino in the state of California and nationally that justifies a high-risk stop because vehicles that have been stolen typically involve weapons.
I think the question is, when does the high-risk stop turn? And you've acknowledged that at some point it can, that the high-risk stop does not, you don't draw a straight line and say, okay, you have to handcuff every time. So I think that's why these questions are coming up, once you see, they ask her to lift her shirt, they ask her to turn around, all of that, why isn't she not a risk at that point?
At the point when she is
Wait,
taken...
do you think it was reasonable for them to think that she was a risk at that point?
It was not unreasonable for them to think that she could be a risk.
Really? Why?
Because
she would be a risk.
they had not conducted a pat-down search. It was a visual search only. It was at a distance.
And they don't use any common sense at all. Like, this is a teeny little lady who's quite old and is doing everything we told her to do and hasn't said one word, and why would I think she's a risk?
There are no facts to suggest that she was old or infirm or otherwise incapable of breaking away.
There are
Old people
facts
commit
to
crimes.
suggest she was old. McArdle said old woman when old lady when she got out of the car.
Right, and there are no facts to explain what he meant by that. There's no disputed facts as to what his analysis was or the conclusion that he reached as a result. Also, Sergeant McArdle is not a defendant in this case.
So, sure, elderly people can commit crimes, but do elderly people who are unarmed overpower 7 armed officers?
It's certainly that is part of the training as a possibility that exists.
That a 117-pound, 83-year-old woman was going to overpower these 7 officers who were holding guns.
None of those officers had that information at the time. Not all of the officers had their guns pointed. There were that many officers present in different positions of readiness. At most, there would have been 4 officers in a position to have acted if Ms. Brown ended up being someone who was dangerous under those circumstances. But to get back to Judge Nelson's question, yes, at some point, the officers will make a determination as to how much of a risk this person or the vehicle.
I think there's 2 questions here. Maybe there's not. If they see that she's not a risk and then they handcuff her, would you agree that that's a constitutional violation at that point?
If they've made the determination that she is not a risk, most likely that would be a constitutional violation yes, at that point. That assumes, of course, that there are no other circumstances.
Also said to her, as was pointed out earlier, but I'm not sure exactly when, after she was uncuffed, well, obviously you're not a risk. So did he say something like that to her?
Yes, Sergeant McArdle did that after she was released, and they were trying to figure out what had happened.
Right, so what did he know between then and when she was handcuffed that made him realize that she wasn't a risk?
We don't have that information in the record.
Seems like what prompted that was the fact that they realized that the car wasn't a stolen car.
Correct.
But that seems to be counterintuitive because you can't rely on that fact for continuing to handcuff.
Correct, but again, we have to take into consideration that we have Ms. Brown who is compliant. And I want to make sure I hit this point because this question came up a lot. Why didn't the officers ask? It's because people who commit crimes lie. They could have asked and she could have said, no, it's my car, or yes, I stole it, or no, I borrowed it. That point is a data point, but it's certainly not dispositive. And the fact that they didn't ask her at that point in time certainly does not bear on whether they acted reasonably under the circumstances in and of itself. Once they make the determination
But
that
they
she
could
is
have
not
asked
a
her for the
threat,
registration, which is what they usually do when they stop people.
during a traffic stop, yes, but not during a felony high traffic stop, a high risk
All
felony
right,
stop like
So
this.
this leads to my other concern. I mean, you're relying on a set of habits, I gather, that the police, you say the police force have. It's not actually in the police handbook, any of this, as I understand it. Is that, how does that inform the qualified immunity question?
It's not a matter of habit, it's a matter of policy. It's
All
a
right,
matter
but
of
it's a matter of policy. How does it inform the qualified immunity standard if it turns out to be an unconstitutional policy?
One, because we're not here with Monell liability, the city is not a defendant. And two,
Do we have, because I couldn't find it, but maybe it exists. Do we have case law? I know we have case law that says that they don't follow protocols. That could be a factor in qualified immunity. Do we have case law that says if they do follow protocols, that means there's qualified immunity?
no, Your Honor, because qualified immunity doesn't necessarily turn on that point alone. The qualified immunity.
It seems to me that you're kind of arguing it does, because you keep coming back to it so often.
It's the relevance to the issue of qualified immunity is whether it's clearly established. If the law were clearly established,
And the protocols don't clearly establish it.
it's a question of whether the protocols, the policies and procedures of a individual police department accurately reflect the state of the law. They have to be updated when the law changes. If the law were clearly established that the officers could not act the way that they did, their policies would have been
So they're
updated.
essentially irrelevant, because we have to know what the state of the law is.
No, they're not irrelevant. They are a window into whether the law is clearly
I
established.
suppose what you would try and say is that if this policy's been on the books for 20 years and no one's ever been found to have followed it and taken an unconstitutional action, that would be relevant to us.
Yes, as an example, if the law had changed, because modern practice for policing is what it is to keep officers from being sued. Law enforcement being the most significant part of any municipal budget.
Is it true that this was flagged by the camera system initially? Is that true in
Yes.
this case? Okay, so that part of green is the same thing. The difference is here they visually confirmed it, and in green they never did.
In green, the system flagged it as a hot vehicle.
Right, which is the same thing that happened here.
Yes.
And then they went and they confirmed that the license plate was indeed the same license plate that was flagged.
Correct.
Green, they didn't do that, and it turns out the license plate was the wrong license plate.
Correct. Sergeant Kim, in the green case,
Is that relevant only to the probable cause, or is that also, green, what's confusing about green is they sort of threw in the kitchen sink on the excessive force claim. And so they have kind of this clean cut version of, when you can use it, and then they throw in, oh, but by the way, it's also unreasonable, or excuse me, it's also excessive because there wasn't a reasonable stop to begin with. Does that muddy the waters for qualified immunity here, or are we okay? I mean, can we just look at the first part of green and say, once there's no reasonable risk to the officers, they can't use excessive force?
it does, Your Honor, and I think the panel has pointed out a number of times that there is a lot of overlap in the analysis between the two issues, even though the issues are discrete. But one does, in fact, inform the other, because you're looking at what goes into initiating the stop, what facts and circumstances do the officers know at the time as the stop is ongoing, up to the decision to use whatever level of force was used, and then in the aftermath. It is a very fluid and dynamic situation, and because of that, the courts continuously.
Now, what is your answer to Judge Beatty's earlier question about, let's assume that the use of the guns in this case was sufficiently different from the use of the guns in Green and Robinson and so on, that in itself would not create clearly established law. But what about disregarding the guns? the question of whether it would violate clearly established law to use the force they used on her without the guns. As your opponent says, the case law is any amount of force that's not unnecessary is excessive force. And the question is, again, once they knew what they knew about her, once she complied, she wasn't armed, and so on, is there, I gather you would say there's still not clearly established law. Why not?
Again, Your Honor, because it's not, the qualified immunity analysis is not, typically does not turn on just one particular point of fact like that.
But the one fact we haven't discussed at all, though, was the fact that the color and make of the car didn't match. That ought to factor in someplace. I understand that there can be explanations for that, but it certainly lessens the likelihood that this was a stolen car, and then therefore lessens the likelihood that she's a dangerous person.
Yes, the fact that there was a color difference is a factor, but it is not determinative in the way that plaintiff asserts on appeal, because as the officers testified and as was included in the evidence on summary judgment, they are instructed, they are taught that the colors can change and that they are not necessarily going to decide not to conduct a stop. That's something
not necessarily, but they did specifically say that it's relevant to the question of whether to conduct a high-risk stop.
Relevant, yes, but it's not determinative, and that was the argument.
How common is this that you get the license plate numbers to match, but it turns out to be a different car? It seems like part of Green was you had a policy saying, we know that these cameras aren't, there's a high degree of error here, and so you have to visually inspect this. Is there a policy on what do we do when I guess you're saying there is, that the colors don't consider the colors.
No, they do consider the colors, you say, as a factor.
Yes, as a factor.
But I mean, your point is they don't have to, for example, if you verify the license plate, that takes care of the problem in Green, which was done here. But the same is not true of the colors. The colors is a factor, but there's nothing that says just because the colors are different, there's not as much of a chance that
that's correct, Your Honor. And the reason,
in fact, it almost seems like it's the reverse, that you should be suspicious of that.
Yes, because that's what the officers call cold plating. It's when you take a license from one vehicle and place it onto another one, which is why they disregard the color.
They testified to that it does decrease, as I understood it, the risk, because if there is he was received CPT training that a discrepancy in color between a reported stolen vehicle and an LPR is a factor to consider when initiating and conducting a felony high-risk stop, but it doesn't mean that you can't do the stop. So in other words, I understand it to mean it decreases the likelihood that it's actually a stolen car, not that it increases the likelihood that it's actually a stolen car.
It is a factor to be considered, and it depends upon the circumstances that the officers encounter at the time. Because a cold-plated car, that license plate came from somewhere. That in and of itself is a crime. There has been a car stolen. It may not necessarily have been the car that the cold plate is on. That car may actually have been in the ownership or possession of the person who owned it, and for some reason they have a different license plate on it. But that's why the change in color is not dispositive, whereas the license plate matching is something that carries much more weight in the analysis that the officers conducted at the time and on the scene. Another thing to keep in mind is that the technology that was used has been refined again and again since when it was deployed in Green, which is in 2012, and the case was decided in 2014.
Meaning that the cameras, there's less of a likelihood that the camera's going to catch a bad license.
There's a less likelihood that the cameras are going to catch a incomplete
Although
match.
that doesn't really matter because they've visually verified here.
Correct, and they visually verified it, but they also verified it with dispatch and received information that the license plate number was in Klets. Those are high indicia of reliability.
Explain to me how the license plate, it's the correct license plate, but it's associated with the wrong car. How in the world did that happen here?
It's not in the record below on the motion for summary judgment, but the facts essentially were that Mrs. Brown had her vehicle being worked on at an auto shop. and it was stolen from the auto shop. She was contacted late at night by the San Bernardino County Sheriff's Department, and when they were taking her information, the best that we can tell is she was either tired and gave them the wrong license plate, or there was an error on the part of the Sheriff's Department in recording the license plate number.
Wouldn't they have put that into a system and then the license plate, the correct, this license plate was given, wouldn't they have put that into a system and it would have brought up the color and the make? And so that's what I don't understand. I just don't understand how the two pieces of information were different. Because if she was tired and gave them the wrong license plate, then that would have gone to the different car. But she gave them this license plate and it was associated with the wrong car. That's what doesn't make sense.
Correct. And again, we don't know.
But you guys can't make sense of it either.
We don't know for sure. The county's not here.
It doesn't really, I'm sorry there's many issues that are relevant here. That one is probably low on the totem pole. But
So do you have any thing you want to say about the false arrest issue? Do you agree that this did turn into an arrest, and the question is whether there was probable cause, or do you look at it differently?
No, Your Honor, we look at this really as an extended detention in order to clear the vehicle. Whether Ms. Brown remained in custody was a question that the officers dealt with based on whether she posed a specific threat that would have continued her.
Remained in custody as of when?
When she was placed in handcuffs and passed through the line.
Okay, but wouldn't that turn it into an arrest when, given all the factors and given the case law that says that if there's no specific reason to think she's dangerous, there's no, the crime was not ongoing, it was not a violent crime as such, and so on, therefore an overly intrusive stop turns into an arrest. That seemed pretty clear.
It's not an overly intrusive arrest based on these facts because of the situation with having the necessity to clear the vehicle, which had not yet been cleared, as well as the very short period of time that she was with the officers behind the line.
There's a list of factors and she meets none of them, basically.
I'm sorry?
There's a list of factors and she met basically none of them.
Those factors are not exhaustive.
Okay, so even though there's a list and she meets none of them, there's another factor?
Yeah, the totality of the circumstances ultimately determines whether.
But that does seem to turn it on its head a little bit. I mean, there's four factors here. Armed, risk, whether the crime just occurred.
Fleeing.
Nothing's met.
But again, the situation with Ms. Brown.
I'm just saying the general safety warrants this.
General principles of officer safety and protecting the public, but yes.
Well, they may warrant it, but that doesn't answer whether it was an arrest or a stop.
The question becomes whether the placing the handcuffs on her transformed it from a.
Not just placing the handcuffs. I mean, there were guns, whether they were aimed in her head or not, there were guns. And she was made to get on her knees, and so on. So it wasn't just a question of being handcuffed.
That's correct, but it is our position that at any point that it could have turned into an arrest, that point would have been at the point that she was placed in handcuffs. But again, that issue is not dispositive. It's really an extension of the detention in order to clear the vehicle. And as we demonstrated below.
Well, there's a difference between probable cause to detain, and then a probable cause to arrest. Do you think they had probable cause to arrest here?
No.
Okay, so if it was an arrest, then we have a constitutional violation. Query whether there's clearly established, but you would agree if there's an arrest here that that's a constitutional violation?
Possibly, yes.
So would you agree that regardless of the arrest issue, if she was arrested or she wasn't arrested, that does not determine whether the force was excessive, the steps they took to put her on her knees and handcuff her, having guns drawn? I mean, it seems to me the excessive force issue is separate from the arrest. But do you disagree? Do you think that matters, whether she's arrested or not, the degree of force they could use?
I think that the degree of force was appropriate regardless of whether it was a detention or an arrest. Are the analysis the same? No. As the panel has pointed out numerous times, there's a lot of overlap, and in the end, there is separate analysis. The question is, under totality of the circumstances, was there sufficient information available to the officers at the time to justify the level of force that they used? And in this case, the level of force was, at some point, by some of the officers, the positioning of firearms. I wanted to make a quick correction. Officer Scott did not have a shotgun. He had a less lethal 40
But no,
millimeter
you
launcher.
couldn't tell that by looking at it. So what difference does that make?
I'm sorry?
You couldn't tell that by looking at it, could you?
I could, yes, but if the question is, would a member of the public know that?
Exactly. So what difference does that make? I mean,
The
as far as
most-
she knew, in terms of her perception of what was happening to her, he was there pointing a gun at her.
She believed that she saw somebody with what she characterized as a shotgun.
Right.
It's relevant
And she did.
in the context of Green, because in Green, and other cases, the presence of a lethal versus a non-lethal weapon platform was relevant, and that's why I want to make that correction.
Even if it doesn't look like it, I mean, it's one thing to have something that isn't lethal. It's another thing to have something that you think is lethal, but turns out it isn't. I mean, I don't see what the relevance of that is.
And the relevance is, Your Honor, from the perspective of the officers on the time, at the time, you had Officer Briley, who provided initial lethal coverage. You had Officer Gregory, who was in a position to provide it if necessary. You had no coverage from Sergeant McCardle, who was observing what was going on, and you had potential less lethal coverage by Officer Scott. That is a markedly different situation than Green.
Wasn't there also a fourth officer who did at some point point a gun? But
I don't believe that that's a fact in the record.
I thought I saw that on the video.
This goes to the question of why this is unreasonable force. It's not unreasonable. I don't know the answer to this. I'm not sure the case law has defined it, but it seems like it's not unreasonable force because of the fear that the plaintiff is under. It's unreasonable force because of the risk of actual harm that comes into it. I could be wrong about that. I don't know.
No, Your Honor, and that's where I was
Is there
getting.
a case that says that?
Yes, the appropriateness.
Say you have, say they don't have any. There's no ammunition in the weapons, so they're real weapons, but there's absolutely no ammunition in them. Does that take away the chance of excessive force?
Not necessarily. It would depend upon all of the other circumstances that accompanied that type of situation.
It does matter what her perception is, more than just the risk.
The application of the analysis is what the officers knew at the time. So it's not a plaintiff-centric analysis, it's what the officers knew.
No, but that's not the question. The officers know that pointing this thing at her, she would think it was a gun. Presumably, yes. So that doesn't help the analysis at all. The question is whether her perception comes into it.
It would be relevant in so much as it may have informed what her following conduct might have been, but the presence of the 40 millimeter less lethal platform is only relevant in so much as when you look at the totality of the potential use of force. Less lethal, not a shotgun, that distinction is important. So I'm sorry I derailed the panel with that.
But in any event, Officer Scott was not close to her.
Correct.
So earlier, you were asked about the statement that one of the officers made. I'm not sure if it was Gregory or McCardle. It's on the video, and he comes up to Mrs. Brown and doesn't apologize, but says, "You understand why we did what we did. Clearly, we can see you're not a threat to us." And you said, well, that's because they'd already cleared the vehicle. How do we know that? I mean, isn't he just making an observation that visually we can see you're not a threat to us? And why should we not, tether that in time to when they're making her kneel down and handcuffing her?
Because it's after the completion of all of the events, both any use of force that may be found, as well as the circumstances for the detention and, if Appellants decides the arrest, it's all after the fact.
Was it after they cleared the car?
I'm sorry?
I don't know the answer to this. Was that after they cleared the car?
Yes, it was.
So he didn't say to her, now that we've brought you very close to us, done all of these things, cleared the vehicle, checked and see that you're the registered owner of this vehicle, now we can see you're not a threat to us. He just said, we can see you are not a threat. It seems a pretty strong statement that the officers could tell by looking at this lady that she was not a threat to them.
If Sergeant McCardle had said that initially, before she was taken into custody, before she was placed in handcuffs, it absolutely would bear on the court's analysis.
Well, Officer Gregory also expressed earlier concern when he said, I really thought about not putting her on her knees. And then the other officer says, oh, but you had to. But he didn't have to. I mean, they seem to be operating somewhat robotically in terms of, thinking they had to go through a certain number of steps when the protocols and their later testimony made clear they didn't have to go through those steps.
Officer Gregory did not have to place her in handcuffs on her knees. This is correct. However, qualified immunity is not based on...
But Officer Briley thought he did. I mean, she said, but you have to do that. But he didn't, in fact.
Officer Briley, as a third-week trainee, believed that that would have been required. However, Officer Gregory, as a 7.5-year veteran who was a field training officer for Officer Briley, admitted that he had discretion on what to do.
Doesn't his statement demonstrate that he also realized she wasn't a threat? And he had to make a switch decision, but why was he even thinking I shouldn't put her on her knees? Because he knew that this was an unusual situation where they had the wrong person.
That's emblematic of the types of decisions that officers make every day in the field based on the circumstances that they're confronted with, and that the entire reason we have qualified immunity. Because we don't want to put the officers in a situation of having to overanalyze and cross-examine other officers to see if they're doing the right thing in the moment. The courts are uniform in recognizing that these dynamic situations can change at any point, and then officers need to have discretion. But if they make a mistake, as occurred here, a mistake was made. We've never shied away from that fact. Qualified immunity is here to protect them from liability.
What mistake was made? Obviously, it wasn't a stolen car. We got that. But was it a mistake in hindsight? When you're showing this video to other officers, or you're like, okay, don't put her on her knees next time.
No, the mistake here was the whole basis for the stop was erroneous.
That's the only mistake you're not acknowledging. You're not acknowledging that it was a mistake. Whether it was constitutional or not, you're not acknowledging that it was a mistake to put her on her knees.
Correct, because Officer Briley's conduct was considered after the fact by her field training officer, Officer Gregory, who found her actions appropriate and within policy.
I know, and we've had a lot of people cleared by internal investigations who are convicted of crimes for killing people with the police. So it's not a lot, but a few. That's not very dispositive of anything.
It certainly indicates that the level of introspection that the panel seems concerned about has occurred here about whether there was something to be learned. Whether there's something to be learned, yes.
Well, that's very troubling. I mean, the rest of what you've said, it doesn't bother me, but the notion that they would do the same thing again next time is troubling.
And that was the analysis as submitted by a court.
We don't want to see these cases anymore. We're kind of tired of seeing these cases. Like, just, I don't mean to be hard on the police officers. We're very grateful for what they do, but why? It really is hard to imagine why they were doing. And I understand that there's training. There's a whole bunch that goes into this, but in these circumstances, I don't know if it's a constitutional violation, but it just doesn't pass the good judgment test.
And that is something for the department to consider. It's also something.
Can you tell us that you'll go back and tell them our concerns, whether they win or lose? We don't want to see this happen again.
Of course.
83-year-old ladies should not be knelt down and handcuffed. Just don't do it.
And if that's something that the officers had known, I think the fact that Officer Gregory had that moment of introspection shows that they are thinking about these issues.
I have one last question, because you're way, way, way over your time. Is there any empirical studies or support or indication of how dangerous it is to stop a stolen vehicle? I understand that things happen and that people can occasionally be violent. There was no evidence here that this was a carjacking or anything like that, or that it was stolen at gunpoint or anything like that. I would just like to know whether this understanding that whenever you have a stolen car, you have an inherently dangerous situation, is what level of risk is that? I mean, is that a 0.1% of risk, or a 5% level of risk, or a 10% level of risk? What is it?
And some courts have dealt with that question. We don't have an empirical answer on a statistical level of danger of this particular subset
of traffic, of
And
stops.
especially when you throw into the fact that it's the wrong car, I mean, the wrong color and the wrong model.
Right, or the fact that it occurred in front of the Chino Institution for Men
And
State Prison.
what possible difference does that make?
The fact that that is an area that is known for stolen vehicles and
And
armed
that's in the
defendants.
record, there's some empirical proof of that?
There is evidence that that is part of the training of Officer Briley and
But that
Officer
doesn't prove
Gregory.
it's true. I mean, people can be told all kinds of things that aren't true.
Correct, but what's also true is that the City of Chino's policy is consistent with POST, Police Officer Standards and Training Commission of California, which is consistent with national policing standards. So, which gets back to the question of, if all of this was so apparent that it was wrong, it would have made
I'm
its
not
way
asking
into
you
these
that.
policies and procedures at some point.
There's still a question of how much risk are you protecting against? And at what point is that risk not there anymore? And when we've now had a series of cases about errors in stopping stolen cars and this assumption that you're going to treat people, as necessarily dangerous until proven otherwise if you think they have a stolen car. So it seems to me, and I know it's not in the record here, that the question of how, whether we're protecting again is, against a 0.1% risk or a 0.5% risk or a 5% risk or a 10% risk is important, and I don't have any indication of it.
That's correct. And again, the cases have noted that there really is a dearth of empirical evidence. There was a study from 2014 that looked at the number of injuries and fatalities for law enforcement in traffic stops generally. One, it's old. Two, it did not parse out this specific circumstance with respect to a felony traffic stop for a suspected stolen car. But ultimately, that's a question that has to be dealt with at the state level. In promulgating post standards and learning domains. It has to be wrestled with at the national level for federal law enforcement. And at the local level, we do learn and we take back every case of these that I do. I take back, what did we learn? What should we do? What should we not do?
Well, we've given you some nuggets. So
yes.
I'd like to
and we're losing the kids in the audience.
But I would like to add to what somebody should figure out is, what is the level of risk you're talking about here? Especially when the colors don't match. The car and the color and the model don't match. Does that decrease the risk significantly? My suspicion is yes. Your suspicion was no. It would be nice to know.
How it impacts it ultimately is something that is shaken out in the training process.
No, it isn't. Not if you're doing it with no empirical information.
Because it
That's
says
the
that
problem.
every case we're told, responding to domestic violence is the most incredibly dangerous situation. A felony traffic stop is the most incredibly dangerous situation. And it's like every one of these cases, the police come and tell us this was an incredibly dangerous situation. And how do we know that? How do we know that they're acting reasonably when they're going in with that assumption? I mean, maybe you're going to say, well, they have to assume it's incredibly dangerous anytime they encounter a person.
No, Your Honor, if anything, that's a situation that has probably guided the national conversation to where it is on policing. I'm not going to stand here and make that statement to this panel or to anybody else.
Well, that's above our pay grade. So,
above mine as well.
All right, thank you. We're going to give 2 minutes for rebuttal.
Thank you.
Thank you, Your Honor. I think the facts are clear that the only assessment that there was any danger to the officers was strictly based on the fact that there was a suspected stolen vehicle. Everything beyond the point of Miss Brown stepping out of the vehicle negated the danger that she posed to the officers. And the court in their Green decision was very clear that the fact that Green was stopped on suspicion of a stolen vehicle does not by itself demonstrate that she presented a danger to the officers. They cited to Washington versus Lambert, where the Ninth Circuit also held that when making a Terry stop, officers may not use highly intrusive measures unless the circumstances reasonably justify it. The law was clear that if the Terry stop suspects are cooperative and the officers do not have specific information that they are armed or specific information linking them to a recent or inchoate dangerous crime, the use of such aggressive and highly intrusive tactics is not warranted. Here, similar to Green, there was no crime of violence suspected. There was no inchoate dangerous crime. There was something stated about potential of other people in the car. Well, Officer McCardle, when he initially encountered the car, he was going in an opposite direction, was able to look through the car. He radioed. There's only one occupant of the car. Officer Gregory,
Before the stop.
before the stop, and Officer Gregory himself acknowledged that he heard that call over the radio, one occupant of the car. Both officers admitted they saw no movement in the car. They saw nothing leading them to believe that there were other people in the car. And if you watch when Miss Brown is placed on her knees and handcuffed, Officer Gregory turns his back completely to the car when she's being handcuffed, and he's holding the gun down at her head level. Yes, it's aimed towards the ground, but it is directly alongside her head, brandished in her face. That clearly shows that they were not actually concerned about the car. The fact that they were notified there's only one occupant, the fact that he turned his back on the car shows that there was no actual threat that they perceived coming from the car. With
So
regard,
can I ask you once again, because it would really be helpful to me.
Sure.
Whether what we know in green about comparatively to this case, where the guns were when? I mean, do we know that in green that, we know they were guns trained on her. Do we know they were near her? They were at her face? They were, what do we know?
they were, okay, so we know that,
Here, what do we know?
we do know that Officer Bradley did aim her gun
Originally, okay.
originally. We know that Officer Gregory had his in the low ready for a majority of the time, that he held it, like I said, brandished next to her head.
But what I want to do is compare it to green. That's what I'm trying to find out. What do we know about what happened in green? We know there were 4 people, I think, who had their guns trained on her. Were they near her? Were they in her face? Where were they?
Yes, so in green, there were multiple officers that aimed their gun at her. Here we have 2 officers that aimed handguns at her and 1 officer that aimed the shotgun. Now the officer—
Not after she was handcuffed.
there is testimony that he aimed it after she was handcuffed, correct? The shotgun. Officer Scott, Ms. Brown in her deposition testimony.
Yeah, but the district court dealt with that, and the district court said, we watched the video, that testimony is totally unsupported by the evidence, so we're disregarding it.
But that's not true.
That was with regard to Officer Gregory, and whether his gun was aimed at her head or aimed at the ground.
But
That was
Scott, you can see out there.
with Scott, he had the gun, the shotgun. There's video and pictures of him with the shotgun aimed at her. He is on the passenger side of the vehicle that Sergeant McCardle is in. Sergeant McCardle is directly in line with her when she's brought to the vehicle. And Officer Scott is just to the passenger side of that vehicle, so an arm's length away with the shotgun aimed at her. So he is in close proximity to her with this
Shotgun.
It's a 40 millimeter shotgun that shoots beanbags.
Non-lethal.
Correct, but perception does.
There's a difference.
Perception does matter, Your Honor. I mean,
I'd much rather get hit by a beanbag than a shotgun shot.
I would certainly agree with that, absolutely. But
All right, I think, I mean, I don't want to cut it off, but at some point we need
No,
to.
it's fine.
understood.
So we've let you, everybody argue, and we've let you argue because you've done such a wonderful job. And please pass along our condolences to your client. I will tell you, we watched these videos. It's really changed the dynamic of these cases, and she acquitted herself incredibly well, and others don't, and that potentially created even a more unfortunate case. So.
Understood.
Thank you.
Thank you.
All right.
Thank you.
Court's going to take a 5-minute recess, and we'd also like to thank the kids. You did a great job. Hopefully you've learned something about how the judicial process works, and we'll take a 5-minute recess.
All